Hi guys, this is Erica from Gokce Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. If you have ever owned land in the rural West, you are likely very familiar with a road like the Weiss Highway. Old mining or trail roads created by unnamed entities years ago and now used by locals as public access ways, but whose legal status is unclear. The Weiss Highway Agreement was supposed to set a precedent for how some such roads in Utah could transfer from federal to state hands. Instead, the initial Memorandum of Understanding between Utah and the federal government caused the whole deal to unravel. What happened is a great example of both how complicated the legal status of rural roads can be and how memoranda can backfire. But more on that later. For first, if you are in the process of working through your own real estate deal, it's possible that you or the other party involved may want to request a memorandum of contract. So in today's video, we're going to cover the top things you need to know. Number 1, a memorandum of contract or a memorandum of understanding is a form memorializing a purchase and sale agreement or contract. It can be used to outline the terms of the agreement before it has been drawn up, or to simply record that a contract has been executed. Number 2, the memorandum of contract is not a formal contract and does not usually create legally enforceable obligations. Its real purpose is to serve as a notice that a property is under a contract, such as a purchase agreement or a seller finance land contract, or to outline basic terms before the contract is executed. However, having said this, as with any kind of legal document, it's important that you discuss your specific document with a local real estate attorney to ensure you understand what exactly your document will be doing. Number 3, memorandums can be used in court when one party fails to meet one or more of the obligations stated in the agreement. That said, to be effective, the memorandum of contract must be recorded in the county property records where the property is located. Again, typically its point is to record a record of a contract that is otherwise not usually recorded, such as a purchase and sale agreement. Number 4, in the context of a real estate deal, the memorandum of contract will typically specify the following information: the names of both the seller and buyer of the property, the common and legal address of the property as well as the property's legal description, and the date on which the agreement or contract referenced was entered into. Now, memorandums are typically brief and do not go into the terms outlined in the purchase and sale agreement or contract referenced. However, additional terms can be inserted into the memorandum at the discretion of either party. And again, you'll want to consult with your lawyer on how to best craft the memorandum of contract for your deal. Number 5, a buyer may want a memorandum of contract recorded in order to ensure the seller won't sell the property to another party in between the time period when the purchase and sale agreement is signed and the deal closes. The reason a memorandum is helpful to a buyer is that once recorded, it will show up in any title search. So if your seller tries to turn around and sell the property to another party, that new buyer's title company will find the memorandum of contract during their search and will flag this and often not move forward with issuing title insurance. However, it should be noted that a memorandum of contract can be a bit of a double-edged sword for a buyer, because in some instances or states, if you later decide to back out of the deal or get into a dispute with the seller after the memorandum is recorded, you could potentially end up liable for damages to the seller. Number 6, a seller may want a memorandum of contract recorded if they want their buyer to pay off a land contract by obtaining outside financing. Most lending institutions will require that a land contract be recorded before the bank will lend to the buyer. So if you are selling a parcel of land using a land contract and you've worked out a deal with your buyer where they will pay you by obtaining a mortgage, you may need to have such a document recorded before your buyer can obtain financing through an outside institution. And number 7, to terminate the memorandum, you will need to record a termination notice or agreement. And this is very important because without such a document recorded, there will be no record that the memorandum is now no longer in place. So again, consult with a local real estate attorney both before drafting the memorandum and at its termination to make sure all appropriate documentation is being recorded. If the parties who executed the memorandum are not willing to release and terminate the memorandum, then you may need to commence an action to clear the title, such as a quiet title action. So this is again why it's very important to make sure the whole process is done correctly, and also why you may want to think twice before having a memorandum recorded in the first place. But let's return to Weiss Highway. This lonely dirt road runs through the harsh landscape of Joab County in Utah's West Desert. The road had existed for decades and was used mainly by the area's few ranchers and outdoor recreators. Running through public land, it had never been made an official right-of-way, and Utah wanted to change this by making a claim to ownership. So in 2003, then Utah Governor Mike Leavitt and Interior Secretary Gail Norton signed a Memorandum of Understanding agreeing to transfer ownership of the road under the mining law of 1866, now known as RS 2477. This law states that public right-of-ways would be granted to a state whenever a highway or road was built over federal lands without needing government approval or even formal recording of title. The law's goal was to help settle the West by making it easy to develop a system of roads over land that was still, at the time, almost entirely federally owned. RS 2477 was repealed in 1976 with the passing of the Federal Land Policy and Management Act, which formally phased out homesteading and codified a new policy of preserving and protecting federal lands. Still, the repeal expressly preserved right-of-ways that had already been established under RS 2477, meaning that states could still make claims to roads created on public lands prior to 1976 that are regularly used by the public. At the time that Leavitt and Norton signed the Memorandum of Understanding on Weiss Highway, Utah had already spent 3 years and several $1 million preparing for a lawsuit against the federal government for the right to 100,000 miles of roads on public lands. Under the Memorandum of Understanding, Leavitt agreed that Utah would drop this lawsuit and claims to any roads in national parks and wilderness areas. In return, the federal government would consider the state's claim to roads on other federal lands, including Weiss Highway, which was farthest along in the claim process with the BLM. The Memorandum of Understanding was supposed to outline a done deal, but instead, it killed it. For once the memorandum was recorded, conservation groups fought back, claiming that the Weiss Highway takeover was not about formalizing a public right-of-way, but rather an attempt by the state to stop the creation of a new wilderness area. After all, one criteria that a new proposed national wilderness area must pass is that there are no public roads within the area's boundaries. The conflict around the memorandum eventually led the Government Accountability Office to look into the deal, ruling that under a Clinton-era law passed in 1977, the Federal Department of Interior was not allowed to recognize any RS 2477 roads without congressional approval, thus invalidating the memorandum altogether. In this way, a document that was supposed to help avoid a lawsuit eventually ensured one would proceed. And this is not the only case where a memorandum of contract backfired on the parties signing it, which is why you should think carefully about executing one in the context of your deal. But if you're curious about what ultimately happened to Weiss Highway, the Wilderness Society and Earth Justice found evidence that the county had signed away any claim of ownership in 1936. State officials asked the BLM to put their claim on hold, but a case is currently being heard in the Federal District Court for the District of Utah to try and find a way of processing claims to 12,500 other right-of-ways. Sometimes it seems like the smallest roads are the ones that become most controversial. But do you have any stories about a memorandum of contract gone wrong? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.